What is the rule of law? Grab a drink, some snacks, and let's find out. Hi everyone, in this video we're thinking about the rule of law. This is a notion that appears in political debates. It's of concern to lawyers, of course. So what does the rule of law even mean? One way into this is to focus on the expression itself. The rule of law refers to law's involvement in ruling over you, in governing you. One quite nice summary of this was given in a recent judgment in the UK Supreme Court, where one of the judges said that at the heart of the concept of the rule of law is the idea that society is governed by law. You might ask, what's the alternative? Well, Aristotle referred to the alternative, the opposite, being the rule of men, as he put it. This idea that perhaps you might have within a particular society some people, some groups that acquire power, perhaps through force or through violence, and wield that power directly over you to get what they want. Imagine, for instance, a mafia organization that takes control, that has power, and is making decisions about you, decisions that are based on the mafia organization's own arbitrary self-interest, its own changing whims. It might be deciding things on the basis of its own sadistic impulses and so on. That's one possible alternative, and what Aristotle might regard as an extreme example of the rule of men, as opposed to a society that is governed by law. So to come back to this notion of the rule of law, this idea that society is governed by law, just to go a little bit deeper into this, we may think of the rule of law, and I think this is a good way of thinking about it. We may think of the rule of law as a virtue or an ideal of legal systems. And by virtue or ideal, what I mean is that the rule of law, is something that a legal system should be striving towards. What that also suggests and helps us understand is that legal systems can comply with the rule of law to greater or lesser degrees. And this helps us explain the ways in which we might say of this particular legal system that it is rule of law compliant to a very large degree, whereas that particular system, no, it isn't. It's struggling in terms of its ability to satisfy what we would regard as rule of law criteria. So the rule of law is a virtue, an ideal, which legal systems should be striving towards, and legal systems can do more or less well in terms of how far they achieve that ideal. And as I say, this helps us neatly explain the ways in which we think about how different societies, different states, different legal systems are more or less rule of law compliant. Okay, next step. This notion, this ideal of the rule of law, what does it actually require? What is its content? Surprise, surprise, this is debated. This is contested to some degree. There are various accounts that are proposed in the academic literature, and one sees various requirements or criteria of the rule of law being put forward by different academic writers. At the same time, it also seems to be the case that there is some agreement among the various accounts on some core content, some core criteria or requirements of the rule of law. So in other words, there seems to be some general agreement about certain criteria, some core criteria. There is also, however, some disagreement about other criteria. Let's start with what I'll call the core criteria. So criteria or requirements of the rule of law about which there seems to be general agreement. There are a number of these core requirements, and I will just touch on some of them briefly. One requirement, most obviously, is that there should be rules. There should be general rules that are being made. The rules that are being made should be relatively clear, as opposed to being relatively opaque and difficult to understand. The rules should be relatively stable as opposed to being unstable, constantly changing. The rules being made should be prospective, looking forward, rather than retrospective, looking backwards. In addition, the rules being made should be promulgated, published to the society at large, rather than being kept in secret, having secret rules. You can already see with much of this that these criteria, the way that they are operating, what they're requiring, this is all going to the ability to guide conduct of the governing institutions, for instance, but also the conduct of us as individuals, what we should be doing, where we stand, how we should plan our lives. In addition, there are two further core requirements that I just wish to emphasize because these are quite important if one is to have a society that is doing well in terms of rule of law compliance. One is that the behavior of government, of officials, should align with the rules that are being made, the rules that are being produced and promulgated and so on. The behavior of government, of senior politicians through to, for instance, the police, the behavior of officials should be in accordance with the rules that are being made. Otherwise, one has a situation within that particular society where one might have officials or governing institutions doing whatever they like, just deciding to do X, Y, Z, wield the power that they have in whichever arbitrary or whimsical way that they see fit. So that's important. If a society, a legal system is to be doing well in terms of rule of law compliance, it has to be doing well in terms of that criterion. And then finally, and this is also important, within a society, a legal system that is doing well in terms of rule of law compliance, there should be independent courts rather than courts that are not independent, courts that are partial or biased. Why is that important? Supposing that disputes arise or questions arise about whether, for instance, the government officials, the administration has violated the rules that they should be following, there needs to be some adjudication of this. And if it's the case that the courts, the judges, are simply in the pockets of the government, then this is not a rule of law compliant society. In order to ensure that government officials are indeed observing the rules that are being made, there have to be courts that are sufficiently independent that they can adjudicate properly, fairly on allegations of breaches by the government in particular, by officials. Okay, great. So that's a fairly rough and ready sketch of some of the core criteria, the core requirements of the rule of law ideal. One other point just to note is that in relation to these core criteria of the rule of law that we've been discussing, we might say that some are procedural in character. So for instance, this idea that the rules being made, these should be promulgated, published to society at large. That seems to be a procedural requirement. Other core criteria actually seem to be going to the substance, the substantive content of the law in question. If we say, for instance, that the rules should be relatively clear rather than opaque, difficult to understand, that is a requirement that goes to the substantive content of the rules in question. Equally with certain other criteria of the rule of law. So for instance, the requirement that the rules being made should be prospective, forward-looking. That again is going to the substantive content of the rules in question. So I think that's another important point. All right, here's where we are. We've been thinking about the rule of law ideal. This is an ideal that societies with legal systems should be striving towards. And we've been thinking about some core criteria or requirements of the rule of law ideal. However, as I mentioned earlier, there is disagreement, contestation about other possible criteria that one might add to the list, other requirements of the rule of law. Essentially, what we find is that some accounts of the rule of law are more modest and some are more expansive, more capacious. The more modest accounts, and there are many of them, focus on those core criteria that we just sketched. Focusing now on additional criteria that might be added to the list, additional criteria about which there is disagreement. There is one criterion in particular that seems to attract a lot of attention, and that is the criterion that there should be adequate or sufficient protection of fundamental rights. If this requirement is added to the list, then one can see how the rule of law notion can be used to evaluate legal systems around the world, not just on the basis of the core criteria that we sketched earlier, but also on the basis of the extent to which the legal system in question is exhibiting adequate protection of fundamental rights. One might therefore, on this basis, query the extent to which apartheid South Africa, for instance, was rule of law compliant. The legal system within apartheid South Africa might well have exhibited rulemaking rules that were relatively clear and stable, and they were being promulgated and they were prospective and so on. But to the extent that apartheid South Africa was falling short in terms of adequate protection of fundamental rights, then this might be a basis to query the extent to which it was rule of law compliant. In contrast to that, for those who favour a more modest understanding of the rule of law ideal, focusing on the core criteria that we were sketching earlier, they might look at apartheid South Africa and say, on balance, this was a legal system that was relatively rule of law compliant. It was failing in other respects. So it was failing in terms of its protection of fundamental rights, but that's a separate matter. In terms of rule of law compliance, looking through that lens, apartheid South Africa was doing fairly well. Okay, so an obvious question is how to adjudicate between these different visions of the rule of law, more modest versus more expansive. Another question is, to what extent does this even matter? These are debated, of course. My own preference is towards the more modest vision of the rule of law ideal, focusing on the core criteria. And I will just touch on a couple of reasons for that. I will be simplifying this a little bit, so please forgive me. The first reason goes back to something that I said at the very beginning of the video. I referred to a nice summary of the rule of law ideal in one of the recent judicial decisions in the UK, where one of the judges said that at the heart of the concept of the rule of law was the idea that society is governed by law. Taking that statement on its own terms, a society that is governed by law, that may require certain things that we were talking about in terms of these core criteria. Having a society that is governed by law, it means that there need to be rules in play. The rules need to be capable of being followed, so they need to be relatively clear. They need to be promulgated and so on. But what that statement leaves open is whether the law being made within that society is morally of a very high standard or, for instance, morally of a very low standard, very wicked. We know that law that's made by us can be very good or very bad, and gradations in between. We know that law can be oppressive, We also know that law can be potentially empowering. So on this view, one can have a society that is governed by law, and that entails certain things. There are rules being made, they are being promulgated, they are capable of being followed, they're relatively clear, and so on. So that's all very well and good, but then that says nothing about whether the law in question is of morally a very high standard or a very low standard. It doesn't say anything at all about whether the law in question is progressive in terms of fundamental rights protections, is progressive in terms of taxation, and so on. So the distinction here is then, as you will sometimes come across, the suggestion that we're concerned with the rule of law, not the rule of good law. So this is one reason why we might favor a more modest understanding of the rule of law ideal. Just going back to this notion that the heart of the rule of law ideal, it's about having society governed by law. The law in question can be good or bad ultimately. Having a society governed by law does entail certain things, but it does leave open whether the law ultimately is morally of a high standard or of a very low standard. A second reason for favouring the more modest vision of the rule of law, focusing on the core criteria, is that it assists us analytically in terms of our understanding. We might say that we have a toolkit, an analytical toolkit, and we have different tools within that toolkit. One of those tools, one of those lenses that we can adopt is the rule of law. So we can use that tool, that lens, to evaluate a particular legal system and assess whether, in relation to the core criteria, this legal system, this society is, or the extent to which it is rule of law compliant, measured against the core criteria that we have laid out. And then we have other lenses, other tools in our toolkit as well. We can also pick up another tool and using that, analyze, evaluate the extent to which that legal system is protecting fundamental rights in an appropriate way. And then there might be yet another tool in our toolkit which we pull out to analyze, evaluate the extent to which the legal system in question is progressive in terms of the rules that it's adopting with regard to the environment, and so on. So we have various tools or lenses in our toolkit that we can use to assess the performance of legal systems. And one of these is the rule of law, an ideal which, on this view, is more helpfully understood in the more modest way, focusing on the core criteria. So these are some possible reasons for favouring a more modest vision of the rule of law ideal. I am simplifying a little bit, as I say, so I hope you will forgive me. You should have a think about this. You should have a think about whether you're persuaded by any of this, whether you're persuaded by the more modest vision, or whether you're persuaded instead by a more expansive vision of the rule of law, which includes within the list of criteria protection, adequate protection of fundamental rights in particular. You should think about whether you're persuaded by one approach rather than another. And above all, why? Why might you favour one approach rather than another? You should also have a think about whether and to what extent any of this matters in your view. Does it matter? Or is this just a storm in a teacup, a bunch of academics having a nice little debate among themselves, and actually this isn't particularly significant? That is, I think, a good note to end on. Thanks for watching and take care.